CEO of the Chamberlains law firm. Chamberlains is a boutique corporate law firm based in Canberra. Chamberlains provide a unique blend of high-quality legal services, training and key legal skills for clients, and innovative problem-solving consulting tools to solve public policy and commercial strategy problems. I'll hand over to Scott, and he has mentioned that he's happy to take questions and to continue with this fairly relaxed kind of style that we've got going. I'm going to move to the back of the room because it's freezing here. Yeah, that's not a good spot. You'll see a lot of people move back.
This is all right because it is in the corner. I don't think it.
Okay. Thanks very much. Thank you for the opportunity to talk to you today. As you just heard, I'm very happy to take questions as we go. Don't leave it to the end. Very happy for this to be a discussion rather than a presentation. Talking about the legal basics. Look, for your startup, the legals are easy. You get 50 grand and you give it to your lawyer and you never see it again. This is the problem with startups, that to start it up right is expensive. And I guarantee you won't have problems if you give the lawyer 50 grand because you'll have no money left over to do anything and therefore you'll have no problems. So what we're talking about today is a look at the minimum viable things that you need to talk about. Now, you have that concept when you're doing product development. What's the minimum viable piece of software? And how do we pick it up and throw it against the wall, and if it works, we'll do it again? It's the same issue with your legals. Because the idea is you don't want to be spending your money on your lawyers. You want to be spending your money on your product, on product development, on marketing, on research, on something else that's actually going to make you money. We will save you money. We will help guarantee that what you're building is worth something. And that's the key bit. What's the minimum viable stuff that we're looking at? When I talk about business structure, protecting your IP, the website, okay, you don't exist these days unless you do have a website. Other stuff you need to know, some tips for getting help. Okay, so in terms of business structures, some options. First is sole trader. That's just you. You haven't created a company. It's you in business in your own name. You go down to regulatory services, you register your business name, and the person doing the stuff is you. It's the simplest way of doing it. It's the cheapest way of doing it. It is the riskiest way of doing it. Because it's you doing everything. If you spend 50 grand on a website and you can't pay for it, it's you who owes the money, not some business entity. Second version is a partnership. Now this is you and someone else doing stuff. The issue with a partnership is that it's joint ownership of assets and profit. It is joint and several liability for the liabilities of the business. So the big issue with partnership is that you're doing something, your partner's doing something, you are liable for what your partner is doing in the name of the business, they are liable for what you're doing. So again, your partner goes off and blows 50 grand on a website and you can't pay for it, the website developer is able to come to you to get that 50 grand paid. And then you have to go back to your partner and get his share of it. So partnerships, relatively easy, there's no extra business structure. It is technically, it's not a separate legal entity, it's just you, it's a separate business, you'll have an ABN for tax purposes, etc. But it's still just you as an individual and your partners as individuals. If you're going to have a partnership, what you want to have is a partnership agreement. There is a thing called the Partnership Act, and it does have minimum sort of criteria. Those criteria are equal ownership of the partnership, and everybody gets effectively a right of veto. You can't do stuff without everybody agreeing. It is an issue with intellectual property, and we'll talk about that later. More commonly, people will set up a company. A company is a separate legal entity. It's a fictitious person that does everything in its own name. The benefit of a company is that if it incurs debts, it is responsible for them, not the shareholders, and in most circumstances, not the directors. There are circumstances in which directors can be personally liable for the debts of the company, but provided you run it properly, that won't happen. So you'll be personally liable if you run the company whilst it's insolvent, which means you can't pay its debts as and when they fall due. But outside of that, this is the main vehicle for engaging in risky entrepreneurial activity, precisely because if it all goes wrong, you can bury the company 6 foot under and get on with your life. The other two types of business structures we've spoken about, your baggage will follow you. Minimum viable setup for a company. When you go, you can register a company for sort of $500-600. You go to the ASIC website. You don't need to go to anyone else to register a company. You can create a company just by going to the ASIC website, filling in the forms and paying the statutory fee. That will give you a company. What you then need to think about are what are its constitution and what we call it a shareholders agreement, which is the partnership agreement that governs how the company operates. If all you buy is a company and you've got shareholders in the company, the main issue with that from a startup point of view, once you issue shares to someone, you can't take them off them, they're property that that person owns. A very common problem we see with startups, they go to their accountant, they set up a company with 50-50 owners of the company, this is fantastic, and everything's going really well, and then one of the partners gets an overseas opportunity and they're gone. That's all really good. Now, while I'm over in London doing my research project, I'd like you to continue to beaver away and develop the company. Now, without anything else, there's nothing you can do about that. Shareholders are allowed to do nothing but just own shares. They don't have an obligation to contribute to the company beyond just owning shares. And in terms of being a director, you can't force anyone to be a director. If they want to hand in their resignation as a director, that's it, they're off the board. So you can end up with freeloaders, and that can cause enormous frictions within your startup group and can bring it all undone. That's why we recommend to people that you have a shareholders agreement. This is the bit that underpins what everyone is going to do in return for their shareholding. Right, it's the agreement about how the company will operate. Some of the things that you need to think about are who are going to be the directors. Now, being a director may sound to some of you like an exciting thing, it might be a good title to have. It carries the potential for personal liability. Under new changes to our health and safety laws, directors are potentially personally liable for failing to ensure the company takes reasonable steps to prevent injury to its workers. So if one of you is a director and the other isn't, the person who isn't is getting a free ride. The person who is the director is putting themselves in the gun. When we do shareholders agreements for small startups, we suggest that everyone's a director, because everyone should be in the gun. It should be an equal bearing of load. If everyone's not the director, then you have to think about, well, what are we compensating somebody for being a director? It's not just a badge, it's a whole series of potential burdens. The shareholders themselves, you have arrangements about what happens when someone leaves. When can people be forced to sell their shares? At what price can they be forced to sell their shares? If my partner goes mad, bad or insane, how do I disconnect from them? And what am I left with when I do disconnect? How do we ensure that this business idea continues to go forward if one of us goes crazy or if one of us just wants out? Because what you don't want, you want to create value, long-term sustainable value, and you need to think about that in the setup so that you're not resulting in your IP being fractured, such that your business idea is dependent upon everybody just getting on. And that's what the shareholders agreement should cover. At the very least, very least, you're talking about what have you got to do for your shareholding, who's got to be a director, and under what circumstances can you be forced to sell your shares and at what price. Look, trust is a potential structure. You don't see it for startups very much at all. The issue with the trust is that you'll hit people. It's actually it's a business structure, but it's not a legal entity. Right? A trust is not a thing. What a trust is a person, an individual or a company, agrees to hold certain assets on certain terms for the benefit of someone else. So while they legally own the assets, they're agreeing that they will act in the best interests of a set of beneficiaries and use those assets in accordance with the trust instrument. Some of you may have family trusts, it's like that, right? The trust company is the owner of the house, but it's, at the end of the day, the ultimate beneficial owner of the house will be the beneficiaries of the trust. We don't see this very much for startups, mainly because the trust has all these extra fiduciary obligations to act in the best interests of all the beneficiaries, etc. And brands still around. You won't get investment on this structure because there's nothing that anyone can really invest in. Maybe for unit trust, but that's normally property holdings, etc. If you're looking at developing long-term intellectual property, people are going to want to see it in a company. They're going to want the company to own it, so that when they buy shares in the company, they're buying shares in something that owns it. This thing is far too flaky as a business structure. Before we get on to IP, there is an alternative business structure which most people don't consider, but which for small startups is actually reasonably viable. It's called an unincorporated joint venture. Now, a company with a shareholders agreement is an incorporated joint venture. It's people coming together under a certain arrangement in order to pursue this project. An unincorporated joint venture sits between the company and the partnership on the scale of business structures. And it's very crucial that you identify, most of you, if you're involved in collaborating with somebody on a project, you're going to have this legal problem, this tipping point of are you a partnership or are you an unincorporated joint venture? And what I would suggest you want to be is an unincorporated joint venture, and you want some documents in place, whether it's just email, dot points, whatever, that would demonstrate unincorporated joint venture versus partnership. Now, what's the distinction? Partnership is where there's joint ownership of assets and joint sharing in profit. So you're coming together jointly. Right? So if you're saying you jointly own something, you are far more likely to be deemed to be a partnership. Unincorporated joint venture is where everybody retains individual ownership of what they are contributing. They're bringing it together to create something and they're sharing in output. So it is possible to have a joint venture in relation to the creation of intellectual property because we're separately contributing in order to create this IP. It can happen, for instance, in films. Yep.
Can you, must the subject of an unincorporated joint venture be a physical person or can it be a company?
No, it can be a company. So it can be two companies.
Can be.
Yep, that's right. Okay, so it's a very common way of doing some property development, etc. So you'll have a person who owns a block of land and you'll have a builder, and the builder will contribute their skills and expertise to develop the project. The landowner will contribute the land. The builder will be responsible for all their own costs. It's not a joint sharing of costs and expenses. It's I will on my coin and at my risk and my responsibility pay workers to do this. And you will at your risk and your responsibility contribute your land or pay workers to do this. And out of that we get this and we share it equally or just to 2/3, etc. That's an unincorporated, yep.
Sorry, you mentioned unincorporated companies for films.
So in some, say, short films, that sort of thing, where people haven't set up a special purpose vehicle to do the film, you'll get, here's an example, you'll have someone come in and write the script. That's the writer. Now, without any agreement in place, the writer owns the intellectual property in the script.
That's great.
Right? You then get a director to come in and shoot the script. Now, without any agreement in place, the director owns the film based upon the shooting of the script. But he's done that in breach of the copyright of the owner of the script, unless the owner of the script is assigned and allowed for the film to be produced based on his script. You've got actors who come in to do the acting. They own the intellectual property in their performance. You've got someone who does the music and the score for the film.
Yeah, but, I'm sorry, but I've never heard of films with unincorporated. I mean, all films in Australia that are legitimate would be done through a company structure. That are legitimate. I don't believe that that's actually a correct way, correct in the summations.
Yeah, so the use of the word legitimate. So all the big budget films, no one will invest in a film unless it's being done by a corporate entity. Don't disagree with that at all. But most of your independent films and your short films, they don't set up a special purpose vehicle to do that. They do it all on their own. We act for Screen ACT. I've seen repeated examples of people getting together and spending 25, 50 grand to make a film, short film mostly.
You set up a company for that?
No, they don't. This is my point. They don't. They should, but they don't. And if you're going to do it that way and you're going to do it on the cheap, you end up with the issue of, are you a partnership or are you an unincorporated joint venture? And it will happen with app developments. People getting together and developing apps, they don't set up a separate company to do it. Very often they just collaborate. And in the early stages of your development, you tend not to set up a company. They tend to develop. What will happen is people will come together as friends, they will exchange ideas, they will develop stuff, someone will write some code, someone will do a business plan. There'll be a whole bunch of intellectual property created before they actually decide, hey, this is a good business idea, let's go down the account and set up a company. Now, if they don't go to that step, and even if they do, from a legal point of view, there's the issue of who owns what. And how do we get it to the point where this new company owns it all? And if it all falls apart, which happens quite often in film, because you get creative differences over how things should be done, who owns what's left? If it all comes a cropper, if this app that you're developing, if you can no longer get on as a team, who has the right to still press on and develop the app? Who can use what's already been created in order to do something new? Or does everyone get a right of veto and nothing can happen and we've got to move on to something else? Yep.
I'd like to ask, what's the liability situation there compared to a partnership where one partner is responsible for the other's best?
Indeed, that's one of the reasons why I think you want to do it as an unincorporated joint venture, because you're liable, in that instance, you're liable for your own debts that you incur. So if it is indeed an unincorporated joint venture, we haven't gone and set up a company and we're still all running around doing stuff and one of us is off developing code while the other is off engaging people to build a website. If it's an unincorporated joint venture, the person doing the code is responsible for their own expenses in developing the code, but owns the intellectual property. And the person running off and doing the website is responsible for the payment of the bills in relation to the website. Yep.
One more question. Joint ventures are very common in the construction industry, and so are consortia. What's the difference?
There isn't one. Consortium is just a different name for an unincorporated joint venture. From a legal point of view, the distinction is: are we doing this as a single entity? Have we incorporated something and chucked everything into the company? And are we agreeing that our share in the joint venture is what we get out of the company? Or are we still in our own names doing all this work and sharing what comes out? The reason why it works in property is they will tend to agree, we'll build this block of units and we'll share 50-50 in the number of units produced. Right, now that is indicative of a joint venture because I'm sharing in output, not profit. I'm not selling all the units and then dividing the profit equally. You tend to get the developers actually physically owning 50% of the units to the extent that they haven't been sold. Does that make sense? So consortium would tend to be an unincorporated joint venture. It's a bunch of people coming together. It's not a partnership in most situations, but the words are used interchangeably. From a legal point of view, the issue is, are you a partnership? Or can I show that you're something other than a partnership? Because you don't want to be jointly and severally liable for everyone else's liabilities. Does that make sense? So the risk in startup land is that everything that you do informally ends up being a partnership. The other risk in startup land is that everything that you do informally means that everybody separately owns what's being created and your IP has been fractured. And just like a farming family that has cut its farm up into too many pieces for it to be viable, you've done the same thing to your business idea. The IP is owned by too many disparate people for you actually to have anything of worth. So protecting your IP, one of the things that you're looking at, one of the documents you'll be asked to do, or if you get outside investors, one of the things they'll want to see is an IP is a founder's IP assignment deed. You've set up a company, now you want to make sure that there's a legal document you can point to that says all of the IP that we have produced has been poured into this corporate pot. It owns everything, and no one has a particular dispute about that. That means you have to be conscious about where your IP resides, right? Everyone who's done something needs to sign something of this nature, and it'll be a clause that should be in your... we provide a separate version of this so that it's a separate document that can be signed. It can also be a term that's built into the shareholders' agreement. The issue with shareholders' agreements is that very often people want to hold their shares in an entity different to the one that's done all the work, and so you run the risk that you're not getting the right people to sign the document. This is everyone that's been involved personally in signing the IP that they have created. Non-disclosure agreements. Once you've got your idea, you'll be off and running and talking to people about it. And a very common agreement, an NDA, is simply, it's a document that gives you a little bit of legal space within which to discuss your idea with somebody and protect it. There's no necessary copyright in ideas. Once the idea is out there, other people can copy it. The copyright is in the actual, is in the expression of the idea. So again, we talk about films. In film, the idea for a movie is up for anybody. The actual expression of that idea in a script or in a particular series of events, that's copyright. So when you're going around talking to people, you ideally have this non-disclosure agreement because you want to be able to protect the idea. What this document does is provide you with contractual protection. So you don't have to rely upon legislative protections, right? There's a whole bunch of laws that underpin how we live, and by and large they work, which is why we think we kind of don't need agreements. But in this space you do need an agreement because you're exposing your idea in situations where the law will not protect based upon statute. And this document gives you that protection. And it's the same for the other side. So you can exchange ideas, you can exchange intellectual property, and everyone agrees that that the idea can't be used, that they won't compete. It's good to have. I know, practically speaking, I mean, to be honest, your rights are only worth what you can afford to enforce them. So, you know, some of this can be a bit pyrrhic, but it's better to have it than not. What I would caution about is so we have a whole new level of collaboration going on online, social media, you know, groups, forums, etc., discussing ideas. If that's how you're going about your ideas, then you're not protecting your intellectual property. But one of the ways this can be a problem, particularly in the social media space, to patent your idea, you've got to be able to show that it hasn't been previously published. So going public with your idea in these sorts of forums can actually prevent you from being able to patent it, instantly undermine it. So you have to think about, particularly in this day and age, it's this issue of collaboration, and I haven't seen anything yet. Yep.
I just want to pick up on your comment that your rights are only worth what you can afford to protect them.
Yes.
Because about a decade ago, an idea was being discussed with an organisation which will remain nameless.
Yes.
We had a non-disclosure agreement, and within 3 months, the idea which we thought we were collaborating on was then featured through their delivery mechanism. And that's exactly what they said to me. Your rights are only worth what you can afford to protect them. You can't take us on, we're too big.
Yep.
And I thought, well, how bugger up? How could we have prevented that from happening? Because I think everybody in the room is probably going to be faced with the same situation from time to time.
I have a whole new, it's not being recorded. I've got a whole new level of cynicism about this space.
You're going to teach us how to chuckle, are you?
Well, we're not chuckle. So, look, we're an innovator ourselves. We've spent the last 3.5, 4 years building a disruptive application for the legal market. And